welcome to this episode of Adventures in Contracting. I am Leona Charles, CEO and President of SBC Business Consulting, where we do all things government contracts. And today we are going to talk about a case with the Michigan Department of Transportation and Survey Solutions, Inc., who you will hear me refer to as SSI. So this particular case is about a subject that is near and dear to my heart. But before I start, I'm going to do just a few house cleaning items. If you are looking to get in touch with me, please interact with this video, leave a comment below, or reach out to us on social media. You can reach out to us on our website, spcconsulting.org. You can reach out to us on TikTok at SPC Business Consulting, on LinkedIn at SPC Business Consulting, or Adventures in Podcasting, or you can just shoot me an email. Okay, back to the case. So again, this is the Michigan Department of Transportation versus a company called Survey Solutions Inc., SSI. So the crux of the case is the government is alleging, and by government I mean the Michigan Department of Transportation, they are alleging that SSI engaged in wire fraud, conspiracy to commit wire fraud, and conspiracy to defraud the U.S. These are heavy charges. Each charge potentially carries up to 20 years for the conspiracy to commit wire fraud charge, 5 years for the conspiracy to defraud charge, and 20 years for each of the 13 counts of wire fraud. So there's a lot going on here. But so what happened? So the government alleges that SSI had a secret agreement where they fraudulently claimed they were a minority-owned business. They overcharged the government, were fraudulently awarded DBE contracts, and tried to have their subsidiary buy the primary business to make it DBE. So there's a couple of things going on in here, and so DBE is near and dear to my heart. My company is a DBE. A lot of my partners are DBE, and for those of you that don't know, DBE is a certification that results in set-aside contracts for disadvantaged business enterprises. It's a race-neutral program, and it's based on socioeconomic status. So ostensibly it covers minority businesses or economically disadvantaged businesses who are historically minority. The covered classes are Asian American, Indian American, or Asian heritage, Indian, Hispanic woman, and African American and Native. So where is the government? Where is it getting its information? Right. This is what we want to know. So here's what the government is saying. So it all starts with this secret agreement. Okay, and so the government alleges that through the secret agreement, SSI has a group of companies. I believe it's about 5 companies or so, and through these 5 companies, SSI has decided between the owners, and there's I believe three of them, 3 or 4 of them, that they're each going to own 20% of the businesses. But there's about 5 of them, and all of these in total will get 20%. Right? So the problem is, if you identify that your company is a DBE, if they're sitting under an umbrella where there is a large parent organization, the subsidiary that you are trying to certify as a DBE has to operate independently and separate of that parent company. So there can't be any revenue sharing or profit sharing where it's less than 51%. That's the baseline of the certification. Operating independently means that you're not taking direction from your parent company. The parent company is not the one signing contracts. The parent company is not the one buying insurance. The parent company is not, the one doing payroll. The parent company is not, all of these things. So, which is a little hard for a subsidiary, right? Sometimes the purpose of of a subsidiary is that you're using your parent's company's muscle to do things. So the government alleges that by virtue of this not being independent, they cannot be a DBE. Also, they're alleging that there is no minority partner. And that is a little bit of a stretch, and I'm going to tell you why. So one of the defendants, I'm going to butcher this name, Semenchuk, is an Asian Pacific Islander, and he is the purported sole owner of the subsidiary. They're saying he's actually a white guy. He's not a Pacific Islander. He's actually a white guy. Why is this important? Well, this is important for two reasons. One, in the U.S., we have the one-drop rule, right? So he may be white presenting, but if he, in fact, has heritage as an Asian Pacific Islander, unfortunately for the government, he is a minority. The percentages are not something that we go into. It has been the percentages has been litigated, but as a rule, it typically is not. It has to be something where they've never identified as a minority before in any capacity that becomes relevant. Otherwise, if your heritage is such of a minority, then you can claim minority status. That is generally how this goes. So the government is contending that Semenchuk is not. He is a white guy. He's not an Asian Pacific Islander. He's a white guy. And also, he's not the sole owner of GEO, who is a subsidiary of SSI. The reason that they're saying that is because GEO was trying to purchase SSI. So it was trying to go from being the subsidiary to being the parent company, which in and of itself is not the issue. The issue is that SSI was not a DBE business. So by GEO deciding, okay, we are a DBE business and we're going to buy this, in order for that to happen, GEO would have to be a 51% owner of the parent company to invoke GEO's DBE status to SSI if it was going to, in fact, purchase SSI. That is not what they did. What they did was they tried to take GEO on paper and make it the buyer of SSI, while still having each of the owners have 20%. And in no world, in no world could the owners each get 20% unless all of the owners were minorities, and all of those minority shares added up to 51% ownership of the company collectively. So that is not the case. The rest of the owners were white guys, and then there's this one guy who purports to be an Asian Pacific Islander. This one guy wanted to buy 20% of SSI and have the company designated as a DBE. And you can't do that. That's just not how it goes. It's not independent of the parent company, because at 20%, you're not operating independently, right? 20% ownership, you're still 80% owned by the parent company. And it's not 51% owned, and it also is not independent, and it also is not a disadvantaged business at that point. So the thing that I think hems most people up with DBE when they go down this road of, I think we should just get certified as a DBE and we can get these set-asides. DBE has a two-pronged test, right? The two-pronged test is ownership and control, right? And they have to be simultaneous. Like, you can't have them in steps. So at the time of certification, you have to have ownership and control. So that means that you have to have 51% ownership of a protected class, has to own 51%, and that 51% owner also has to have managing control of the day-to-day operations of the business. They have to sign the checks, they have to sign the contracts, they have to determine the strategy of the company, they have to lead the staff. So they can't be a remote CEO. They have to be the person that everyone goes to. And this is something that I spend a lot of time with, talking to my clients when they decide that they want to get certified, is that, listen, There's a two-pronged test. You have to meet both of these simultaneously at the time of certification, right? So if you have a partner, you have to make 51% ownership and decision making. Has to be you. It can't go to, oh, well, I just handle the sales, my partner does all the back office stuff. That is not going to cut it. You have to operate the business. If you are a subsidiary and you have a parent company, you can get certified. That subsidiary can get certified as a DBE, but it has to be an independent business. That means everything has to be separate from the parent company. And that kind of untangling is complicated, but I am here to say it can be done. It's not like unheard of. It can be done, but it is very, very complicated, and it takes a lot of effort, and it's heavily scrutinized. Okay, so they are alleging that SSI fraudulently claimed they were a minority business. They were not. They overcharged the government in their billing, and this is a TINA charge, so I don't really understand why it's in here. And they were fraudulently awarded DBE contracts consequently because the government is alleging they should have never been certified as a DBE. So what does this all mean? So I've talked a little bit about 49 CFR, which is the DBE regulations, right? Which are centered on control and ownership. And I have to be honest, when I first started this researching kind of this case and kind of reading the court documents, I expected more from the government, but in reading this, what I've really understood is that this is a TINA charge, which if I was the AG is what I would have said. I would have said contractual matters are going to fall under financial claims, possibly. This DBE claim is a little less cut and dry, and you've not really proven that. I think it's a weak charge. They're alleging that the MBE is fraudulent, and they're alleging that it's based on 70% of SSI's business account payments, excluding personnel costs, were paid through GO. The evidence indicated that the transactions were arm's length, and MDOT basically disagreed with that and concluded that SSI wanted to expand GO, eliminate competition, and ultimately make a profit, and that was the only reason to obtain SSI's DBE certification. So they didn't agree that the evidence showed that it was arm's length transactions, and this is what led to the fraudulent DBE charge. One of the things that is a smoking gun is an email that MDOT alleges that Jeffrey Bartlett sent to Simachek and the other partner, Thalen. So it is 3 partners. I apologize. The email has a subject line that reads accounts. And it says, "Not bad for a bunch of white guys trying to be a minority-owned business." And that's pretty damning, because at that point, you really can't say, oh, well, you really can't say, oh, we're kidding, but that is literally what their lawyer is saying. Their lawyer is saying that you're cherry picking one quote and misconstruing its context. I don't know what other kind of context it would be in, because it seems pretty straightforward, but that's what they're saying. The government is also saying the secret agreement, which in all reality, to me, seems like an operating agreement. So the secret agreement thing, I think, is a bit of a stretch. It's a misnomer, and it's kind of a red herring. And to be quite frank, the way these guys have done things, the government has kind of positioned them as criminal masterminds, and I don't really think that they're smart enough to do that. The way that they've made, the mistakes that they've made, the way that they've tried to go about doing anything, if anything, they're opportunists, and they saw an opportunity to do things, and they were like, let's give it a shot. I don't think that there's some criminal masterminds. I don't see that level of intellect and capability in the court documents that were filed. What MDOT did do is they questioned whether SSI was actually controlled by Jeffrey Bartlett because he was an experienced surveyor. And he owned SSI before Geo's purchase, and he still owned 48% of SSI after Geo's purchase. So, I mean, just math, it obviously can't work, right? But also, this is what I'm talking about in terms of control. If he's the experienced surveyor and that's kind of their field, and all of the other owners are kind of like administrative, maybe they're banking or business guys, then you are going to kind of question, well, how are they making the decisions? They don't understand the technical aspect of the business, and that's exactly what MDOT was questioning. Also, in questioning the secret agreement, MDOT maintained that in reality, Simonchuk owned only 20 shares of SSI, equal to all of the other defendants, and he never had ultimate managerial control. So this goes back to what I was talking about on control, right? So when the government is doing the two-pronged test to see whether or not you are qualified to be a DBE, that control, they're talking about managerial control. They're not talking about, you are selecting what opportunities to chase. They're talking about the day-to-day function, operational functions. Who controls that? That's their litmus test. Who is the one that the staff goes to and says, hey, something's broken and we need permission to fix it? Who do vendors call? Who do banks call? Who signs the checks? Who's on the bank account? Who signs the contracts? Who has legal authority over the company? That's what their litmus test is. They want to know who has managerial control. Who does the buck stop with? That is what they're looking for. So the government has laid out, he doesn't have the technical experience. He doesn't have the shares. He holds himself out to be a white guy. He's not minority. So this is why they're saying at this point, any contracts that they have received up until this point, and they use the email that says, hey, not bad for white guys, as evidence that they were fraudulently awarded to them. And so this is where the government is coming from. Now, I will say, the way that they have gone about, one, the nefariousness of the secret agreement, I think is overkill and it's overreach. I don't think that there is a secret agreement. I think there was an operating agreement or a profit share agreement, and that's pretty standard in business. I just think, like I said, they were just too stupid to understand that the government was going to look at that and say, this speaks to control. So I don't think there was any nefariousness from the defendants, because I just don't think that they had the aptitude to do that. Given what was presented by the government, I just think it was a profit sharing agreement. That's what they agreed to. I don't think it was some long running scheme to defraud the government. It certainly doesn't seem like that from the evidence that the government has presented. So aside from that, the government also alleges that the defendants knowingly devised, executed, and aided and abetted each other in devising and executing a scheme to defraud and obtain money from MDOT. To prove this, they go back to that white guy email, which basically says, the second part of that is, and we're gonna bill the F out of the government. Again, I don't think this looks great, but I think it's a bit of a reach, right? Basically, they're just saying they're going to bill for everything. You could argue they're just saying they're going to bill for everything. The government's arguing that's basically highlighting and showing that their intent to defraud the government, and that they used they charged more in overhead costs and fixed fee 11% than they originally were quoted to have done. I just don't. I don't see the grand. I don't see the grand plan in terms of like the government. Like the government is trying to the government's trying to paint this really heavy picture, and they've kind of slapped them with a lot of heavy charges. And I understand the amount of contracts that they've had. I understand the amount is somewhere something less than between 5 and 7 million, right? It's not a small amount of money. However, 49 CFR caps your assets at 1.32 million, and I believe that's gone up to be counted as disadvantage. So it's not like they robbed people or they robbed MDOT consistently of all of these contracts. They didn't. They presented themselves, and they currently advertise themselves as a premier consulting firm which specializes in geospatial and surveying services, and that's what they do. So there's no fraud there. The equal ownership, again, is not a secret agreement. It seems like it's a profit sharing agreement, and it seems like it's just, what you do when you own multiple companies, you do a profit sharing. They're alleging that it's secret because it's signed by all the defendants, and it reads, "It is the intent of this agreement that the buyers and sellers will each own a 20% undivided interest in the above-named companies at the completion of the buy-in period. Regardless of how the articles of incorporation, stock ownership, or bylaws are written, the intent is for all 5 parties to have equal ownership of the company at the completion of the buy-in." So I apologize again. I was wrong. It's 5. I thought I was wrong. It was 5. It's 5 owners, not 3. The intent is for all 5 parties to have equal ownership of the company at the completion of the buy-in period. Does this look bad? Yeah. It looks like you intentionally were going to have like some phony books, and that's what they're trying to do. Does it prove anything? I'm on the fence, because if you take it at face value, all it says is that, listen, as we acquire companies and we're negotiating those things, the superseding fact is we're all going to have an equal share. That's it. Regardless of all of these things, the articles of incorporation, stock ownership, which coincidentally do change as companies grow and expand, it's going to be superseded by this clause which says we have equal ownership. I don't know that is sufficient to prove fraud or intentional fraud. I don't know that. I don't see it. If somebody else has a different take on it, I'd love to hear it, but I don't see it. So this is what the government is leaning on in terms of a secret agreement, and I think that's just a bit of a stretch. It's a red herring. It's really not that nefarious. They're saying that also to accomplish this, the defendants would offer fictitious loans to one another and take fake loans from the SSI group entities with the expectations that the loans would never be repaid. So now, if that is something that is occurring, that obviously is fraud, and that is something criminal and should be prosecuted if that's happening. However, they don't actually present any evidence for it, which I find really crazy. The only thing that they really present as evidence in this document is a redacted email that states we need to keep bonuses under $350 and the rest of the loans will never be paid back. There's some discussions about how the loans were, if they were maxed out. The only problem is that the government does not put forth any actual evidence to show that's what occurred. The email, don't get me wrong, is terrible. It's bad and should not have been done. But it doesn't prove anything, if that makes sense. And it's really flimsy evidence, and I'm kind of surprised that that's kind of what the government put in this motion. It's just really not great. Then they are alleging that they're gonna defraud the government again to fraudulently recertify SSI as a DBE, even though they weren't, because Simonchuk is purported to be the sole owner, and he's not, and he's also purported to be Asian Pacific Islander, but he's white presenting, so we don't think he is. Again, I think that's flimsy evidence. They've got him on the ownership piece of it. We know with the superseding clause that he only owns 20%, which is not a controlling interest, right? So they've got him on that. That alone, for me, I wouldn't. The way that I look at it, I would not have chosen to go the route of he's not a minority when they had more than enough evidence to just say it's fraudulent based on the ownership piece, because that superseding clause shows that he is not a majority owner. He only owns 20%. Therefore, he should not have been a DBE. Therefore, any contracts that they got should not have been given to them. They were not a responsible bidder. So that's what I would have gone. I think the Asian, I don't know why they're picking on his race. He's not or hinging on whether or not he's a protected class. I don't think that's a winning argument. I think it's kind of silly, and I think it's a little petty, and I don't know why they're pursuing that when they have a slam dunk with the controlling interest. Let's see. Their real point, though, is that 70% of their business accounts were paid, from SSI to Geo, right? And so Geo wasn't independent because it was getting 70% of its money from SSI. So again, they have him on ownership and control. So I don't understand why they are harping on whether or not he fits one of the protected classes. And that's basically what it is. And here's my thing. Here's what I think happened. I think during this whole kind of investigation, because 49 CFR requires that you go through an investigation, they have time to respond, they have time to refute the allegations and provide evidence. I think because Michigan DOT settled, I think that the FBI agent was a little miffed at that and didn't think that they should have been allowed to settle. And I also think that it feels like there's some personal animosity in here because the evidence is just so flimsy on anything other than control. Even the overbilling could very well be explained by their accounting system. It doesn't automatically say to you, oh my God, they were charging so much extra money. Like, that's not what you get when you look at the funds. It's not, it's an 11% increase. That also could have just been a de minimis overhead amount. There are a lot of things that could play into that. And I just think it's such a slam dunk on control and ownership. I don't really understand why the IG went on protected class and billing. It's such a slam dunk on the other things. And it feels like a little bit of an overzealous reach, mainly because they're saying SSI auditors did not evaluate key risk areas as required by the regs. They did not appear to follow the regs with leases or rental costs. Kind of all of these things that they could have used in a TINA complaint. They could have gone another way, and it would have been, I think, much more effective in a TINA complaint than to do it this way. And they looked at vehicle and equipment loss, they looked at salaries and incentive compensation, real estate, managed IT costs, and all of these things could have just been an honest mistake. To which point, the committee, the pre-qualification committee, issued a decision that just said, hey, can you just submit a re-audit of the 2017 indirect costs? And they required them to use 110% direct cost rate on all future invoices until they approved the re-audited indirect costing that they submitted, which to me is a normal, rational decision. Like, that's rational. Well, the FBI agent didn't like this decision. And to me, it seems like because the FBI, he actually puts in here, he disagreed with the commission's or the inspector's decision that, SSI was the cheapest for the best value and the amount of time it would take to get the projects done. And it seems to me that he or she thought, I'm sorry, I'm gendering him, he or she thought that they should have been punished further. And because they weren't, now we have this kind of case, which in all fairness seems to be a bit trumped up. There's no secret agreement. There's really no nefarious long-term plan to defraud the government that they've presented. Now, I'm not saying that these are good guys, because these look like terrible tools. They don't look like good guys at all. But I'm saying from the evidence that's presented in these documents, it doesn't seem like these guys had the capability or the desire to run a long-term con on the Michigan Department of Transportation. Because, well, let me say this. If I'm wrong, and that is indeed what they were doing, they are terrible at it. Terrible at it. They are like the worst criminals I've ever seen. They are not good. They put everything in writing. They put so much in writing. Like, they are just so bad at this. If in fact they are trying to defraud the government, they are so bad at it. What I think happened is you got a group of guys who you got one guy who's probably really technically skilled, and then you kind of got four other guys that are just like hanging out and making money, and they see an opportunity. I feel like they're opportunists. They see an opportunity and they're like, let's try it. Let's see what happens. Okay, what happened is not great. So now they know not to do that again. But I do not think that these five guys are intellectually capable of the level of nefariousness that the government is alleging. I just cannot see it in what the government has presented. It just is not there. I do not see it. And I also do not understand. I mean, after interviewing the MDOT official, FBI Special Agent Mitchell King reported that MDOT no longer has a mechanism to prevent SSI from working with MDOT. Schaefer believed that if SSI were indicted, they would be suspended from participating in federal contracts, and if convicted, SSI would be debarred from federal contract, and that would preclude them from doing business with SDOT. So MDOT was like, hey, it'll take care of itself, because if they get debarred, they can't get contracts anymore, and that solves the problem, and we don't have to do a whole bunch of song and dance. I mean, is it great? I mean, it's relative to the situation. I think it's efficient and it's effective because it's true. If they're debarred, they can no longer get those contracts. So the problem is moot, right? I don't think that this is a terrible line of thinking. SSI has not been conducting any new business with MDOT as a prime. They've been working as a sub. I mean, realistically, they're debarred. They are not able to work as a sub either. So that should not have been occurring. But that was one of the Agent King's issues as well. He also had an issue with SSI's counsel, Wade Fink, in meeting the highest levels of MDOT in an effort to come up with the amount SSI would pay back to MDOT. And because his issue was if they paid MDOT back, then they would be able to work again. But that's really not how debarment works. Once you're debarred from contracts, you're debarred. It doesn't matter if you've made the restitution. You're debarred during that debarment time of 7 years, or 5 years, I'm sorry. You're debarred. Like, you cannot work. Like, I understand that you've paid the money back, and that's great. You've made part of it whole. The other part of that is your exclusion from working on any federal contracts. That's just part of it. Like, you don't get to do one or the other. You get both. And so Agent King has an issue that he thinks that because they paid it back, they are going to be allowed to do work for MDOT again. He also has an issue with the audit provided by SSA. He said it doesn't pass muster, and that OCA didn't agree with, or OCA's MDOT is their office of Contract Administration didn't agree with the numbers. And he also didn't agree with the basic posture that SSI is cheap, they're the best at what they do, and there's a lot of work on the horizon. So my feeling is that Special Agent King had kind of an axe to grind, and this investigation really kind of puts into the spotlight, I think, issues that are common in government contracting, right? There is a lot of work on the horizon, and if an agency is comfortable using someone, they're getting, lowest price technically acceptable, and they happen to be the best at what they do, I think there's a lot of incentive to keep them on the job, because you have to remember that in contracts you have a fiduciary responsibility, right, from the agency standpoint, to be a good steward of federal funds, of public funds. And so that is more than likely going to be the position, because in order to be a good steward of federal funds, of public funds, you do have to look at what they cost, the best value, and the anticipated projects, and you have to balance those. So I think, how do I say this? I get that Special Agent King thinks this is not fair. And I get that Special Agent King thinks that this is not right. And I get that Special Agent King thinks they should not be able to work again. But that is not how this works, right? Once they have concluded their debarment period, they will be able to pursue contracts. And if the agency has determined this will make us whole, then that's kind of the end of it, right? I understand that it doesn't seem fair, but Special Agent King had the lowest level. He had a preponderance of evidence. That's all he had to submit. And even still, I don't think that any of these things, could you make a case for, I guess if you worked hard enough, you could, right? But just like on face value, these things are not they're not that great. And then he asked the judge to make them a flight risk. They had a $10,000 bond to make them a flight risk, for them to surrender their passports, for them not to be able to leave the state of Michigan, for them to, I'm having a little brain fart here, but for them to not be able to leave the state, and for them to not have firearms, which is a lot. I don't understand why, and it really doesn't matter. We don't have to understand why, but it seems to me that he just feels like it's not. The Special Agent King just feels like it's not fair. They shouldn't get to do this. They're telling lies, and they should not be able to work again. And that's not the way this works. So unfortunately, most of the time I'm here giving you guys cases in which contractors behave badly. And on this case, the contractors certainly did behave badly. But I think the government behaved worse. I think that when MDOT issued its decision, I think that decision should have stood. I think it was an overreach for the IG to say, now, we don't like that. We think you should have more, and we're going to give you more. I think they should have let it stand. I think it was sufficient. I think that MDOT could have done more. Absolutely. They could have said, you know what, maybe next year we're not going to exercise the option. We're going to let you get your house in order, and we're going to take away your certification, because I think taking away that certification would have hurt them more than all of this combined. So because they would have lost immediately $7 million in contracts. So if I were at MDOT, that's what I would have done. I would have decertified them, and they would have no longer been able to do those contracts. That would have given them a huge kind of kick in the pants, and it would have provided the most amount of discomfort. What they've done now, I think, is a breach. Like I said, these guys don't seem to have enough brain cells between all five of them to put together some nefarious secret agreement to defraud the government long term. I don't understand why the government is going after billing and whether or not they're a protected class when they could have certainly made the case that they were fraudulently certified based on control and ownership alone. So I'm kind of mystified as to why it was done that way. And it does seem like a reach. The judge agreed. He denied all of their conditions for bail. He thought it was preposterous, and he thought that the government had not submitted any evidence to require a restriction of travel or surrender of firearms or licenses, and a surrender of the passport and reporting to pre-trial services. So it's interesting. I'll keep an eye on it, but this is one of those situations where I think there was definite overreach, and I don't understand the government's rationale, and I don't expect them to win in this case. So that's it. Thank you for kind of listening to me ramble on about this. Any comments that you had, I'd love to see them, and I'll see you next time.